This is session 2 on the Asia and Pacific region. We will discuss on the nexus between human rights and climate change and pay attention to the key issues on climate change in the Asian and Pacific nations and the role of advisory opinion. This session is moderated by the World's Youth for Climate Justice, and I'm your host, Dulki from Sri Lanka. Before starting our session, I have to share the amazing news that 10 additional countries have co-sponsored the initiative, resulting in a revolutionary number of 115 countries supporting the request for an advisory opinion on climate justice from the International Court of Justice. The voting at the United Nations General Assembly will take place at the end of March, and co-sponsorship is still open. Please call on your governments to support and vote yes to the ICJ advisory opinion resolution. A kind reminder that interpretations in French is available. We have 4 distinguished speakers who graciously accepted our invitation to speak in this regional session. And also the Q&A session will be open for after each speaker. So please keep your questions ready or type them in the Q&A box. I would first like to invite our first speaker of the session, Professor Dr. Kokila Konisinghe. She's a professor in law and the acting head of the Department of Public and International Law of the Faculty of Law, and also the coordinator of the MPhil and PhD programs in the Faculty of Law, University of Colombo, Sri Lanka. She's the founding director of the Center for Environmental Law and Policy of the University of Colombo. She's a member of the Commonwealth Futures Climate Research Cohort 2021 and 2022 of the Association of Commonwealth Universities and has represented Sri Lankan official delegation at the United Nations Climate Change COP27 in Egypt. She's also the first advisor of the WYCJ Asian Front. Her book chapters and research articles have appeared in locally and internationally reputed journals and publications. She won the University of Colombo Senate Award for Research Excellence for Legal Studies in 2020. Professor Konisinghe, thank you so much for joining us today, and the floor is yours, ma'am.
Thank you so much, Dulki and the organizers. May I kindly request to make my cameras available? Okay, right. Thank you so much. Ayubowan, and this is a very much privilege for an academic who is very passionate about environmental protection, particularly climate change, and from Sri Lanka, the Asian and South Asian region particularly, to speak and contribute at this World Youth for Climate Just Forum. And first of all, I must appreciate and give full credit to the youth who has engaged and organized, coordinated this much needed effort. And it is very special because it is particularly by the youth. So we talk about intergenerational equity, and we talk about present generation's responsibility towards future generation. So I think it is very, very ideal situation and a platform that I have been privileged to talk. So thank you very much for the organizers and Dulki from Center for Environmental Law and Policy from Faculty of Law, University of Colombo in Sri Lanka. So it is my utmost pleasure. And when I was invited, I thought that what should I share? So there were a couple of options for me, and I could share some of the updated information on Sri Lankan climate change context and the contributions we have made, or I could have shared some of my current research, which is particularly in climate change and rights of nature approach. But finally, I found a very fascinated area to share with all of you. Why I tell that it is very fascinated? Because in 1997, there was another advisory opinion given by International Court of Justice on threats and use of nuclear weapons. And in the panel of judges, there was a dissenting opinion expressed by one of the judges, who happened to be a Sri Lankan. And today, in 2023, this young group of activists in climate change, Voice for Climate Justice, we together voice and we together request for advisory opinion on an issue and an environmental challenge, just like in 1997, as a Sri Lankan myself contributing to it. So I thought it is a very interesting combination if I make a comparative analysis of 1997 advisory opinion on nuclear weapons and today advisory opinion on climate justice. So it's a nice combination. So I started my research on this and then I found many interesting reflections on this. Therefore, let me share my screen and discuss about how I would see this comparison and how I would recommend and give you some ideas to improve your dialogue towards requesting for advisory opinion by the International Court of Justice. May I have the sharing option, please?
Ma'am, it's it's already given to all panelists, ma'am.
Can you see the screen?
Yes, ma'am. We can see the screen.
Right. Thank you. Right. Now, you can see the picture of this Honorable Judge C.G. Veeramantri. I'm sure if there are law students here, this name is very familiar because in Hungary versus Slovakia case, the same judge gave a magnificent ideas on sustainable development, intergenerational equity, and precautionary principle, and many other international environmental law concepts and principles. So in this particular judgment, in this particular advisory opinion, Judge Veeramantri gave a dissenting opinion. And I kindly invite everyone to go through his dissenting opinion, which is so in 1997, Judge Veeramantri mentioned, I quote, "My considerate opinion is that use of nuclear weapons is illegal in any circumstances whatsoever. In principle, it contradicts the fundamental principle of dignity and worth of human person on which all law depends. It endangers the human environment in a manner which threatens the entirety of life on the planet." I can't see any other similar way or any other better way to bring out our argument on climate justice. As climate justice today endangers human environment in a manner which threatens the entirety of life on the planet. So in this particular advisory opinion on legality of threat or use of nuclear weapons, the General Assembly applied this application to under Article 296 of the Charter of the United Nations, just like the World Youth for Climate Justice is going to do. from the International Court of Justice. And the International Court of Justice gave an advisory opinion. And lessons learned from this advisory opinion in 1997 for the advisory opinion that we all are going to apply for, that broader application of international environmental law was reflected in every judgment. And also application of customary international law define general norms of international law. Now, this particular definition on general norms of international law as well as application of customary international law is very important, because this particular argument on climate change has not established properly within the legal jurisprudence anywhere else. Therefore, it is very, very important that we get an advisory opinion, just like in 1997 nuclear weapons advisory opinion, on what is the application of international environmental law and customary international law. So that definition will give a heavy weight to our argument. And also future projections from this 1997 case, that the court held that this this threat of use of the threat or use of weapons, nuclear weapons, would be lawful or unlawful in an extreme circumstances. Yeah. So in an extreme circumstances of self-defense. Now, Judge Veeramantri did not agree with this. He said under any circumstances, use of nuclear weapon is should not be accepted. But the majority's opinion was under the self-defense, the use of nuclear weapons should be allowed. So that is why they have mentioned here would be lawful or unlawful in an extreme circumstance of self-defense. Now, there is an obligation to pursue good faith and to conclude negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. Now, may I request all the young people, all the youth around the world who are joining here with us today to pay attention to the last paragraph of this slide. That is, in 1997, in the advisory opinion, the ICJ mentioned that they invited all the member states, state parties to the UN to take actions to conclude negotiations leading to nuclear disarmament. Now, we are also in the same position with the climate justice. So the negotiations and climate carbon emission standards are not being applied and take actions at the same level by all the nations. So there's this South-North dimension, South-South dimension, and there's a lot of debates between industrial countries and emerging economies. So therefore, I think it is very, very important to take a judgment as an advisory opinion by the ICJ, mentioning that all the state members have the responsibility and every state should act in good faith to conclude negotiations for a productive outcome. And these are some of the environmental law principles which were discussed in this case. And also these principles can be used by us in this particular advisory opinion on climate justice, intergenerational equity, common heritage principle, precautionary principle, and you can see all the principles that I have mentioned here, and also common but differentiated responsibilities principles. And let me elaborate on the advisory opinion on climate change. Now, just like in 1997, we have this the youth have now begun to ask for requests for advisory opinion by the WYCJ. Now, the advisory opinion seeks to clarify the obligation of states to protect the rights of current and future generations from adverse effects of climate change. Now, this is very, very important because the debates and the disagreements and not taking responsibilities towards accomplishing the proper standards of carbon emission by certain standards who happen to be, unfortunately, the worst emitters in the world. Now, with this advisory opinion, I think there is a binding, not legally binding, but morally binding, and also before the international law, I think it's a kind of a naming and shaming process is there unless you comply with the necessary required carbon emission standards. So therefore, ICJ's judgment on as an advisory opinion, it will be very, very important and a significant contribution towards this particular case. And the objectives, as I identify, to clarify and define international environmental law principles, and secondly, to lead the nations to work out climate negotiations, just like Judge Veeramantri mentioned in 1997. So it is the duty and the responsibility, according to the principle 21 of the Stockholm Declaration, states have responsibilities as well as duties towards protecting the nature by their actions. Therefore, the states should work out climate negotiations productively and positively, and also to influence every member state to cooperate with global climate standards. So international law principles founded, I mentioned couple of principles that can be founded, and future projection, if I may elaborate. Now, the states should comply with the global standards and take the like they are within the available scientific facilities, the maximum cooperation should be extended by the states towards climate change and other global standards. Now, how can we make use of this advisory opinion? Now, this will be as I mentioned, that 1997 nuclear weapons advisory opinion and also climate justice opinion, this is a comparative analysis of the two cases. So I would invite all the audience to do this comparative analysis and get what there are many similarities in the both cases if you do the case study. So we can make use of many arguments and also many justifications and philosophical debates that were discussed in this nuclear weapons case. And Sri Lanka, as a climate vulnerable state, I think we look forward to have this advisory opinion, because we as a state have done enormous contribution towards the protection of nature and prevent climate change. So we have taken many precautionary actions, even though we are down the list of emitters, because we contributed to the climate carbon emission at a very minimal standard, but we contribute enormously as much as possible towards the protecting the earth from climate change. And also, this is maybe the only way forward for the protection of humanity for future generation. And also, I would like to mention rights of nature towards ensuring protection, conservation, and evolution of natural objects, not only human beings, but also natural objects. And also, human beings should act as custodians of nature. So this is an ideal situation as far as I see, that getting this advisory opinion and we act as custodians of the entire nature. And fairness and rationale, as well as non-discrimination and equality, are another principle that I would like to highlight in this case. Finally, let me conclude with Judge Veeramantri's statement, and let me quote: no one knows how widely such lethal radioactive particles may be diffused. But the best authorities are unanimous in saying that the war with H-bombs might possibly put an end to the human race. Now, while I'm reading out this, I also invite the audience to reflect on this and see the similarities that we can bring out these arguments with the climate change, because the whole world, entire world is facing the same threat, even worse threat to nuclear weapons with the climate change today. Let me quote again. We appeal as human beings to human beings. Remember your humanity and forget the rest. If you can do so, the way lies upon to a new paradise. If you cannot, there lies before you the risk of universal death. So with paying gratitude to this Honorable Judge Veeramantri and his dissenting opinion in nuclear weapons case in 1997, let me conclude stating that the support and advice and guidance is given to this particular project gave me immense pleasure, and I will continue to do so, not because I am an advisor for the Asian region, but I am a human being who is living, and my final survival will be rely on this judgment and the way forward, as well as my kids and the future generation. Thank you so much. Aibowan.
Thank you so much, ma'am. Thank you so much for sharing this wonderful presentation and your expertise. I am sure that all of the participants in this conference have learned a lot, not only on the advisory opinion on the climate justice that we are seeking, but also on the important advice, dissenting opinion by Justice Veeramantri in the advisory opinion on legality of the threat or use of nuclear weapons. Thank you so much, ma'am. I myself learned a lot, as always. I learn every day from you. So many thank you. And if there are any questions, then I would like for the participants to ask them. The floor is open for questions. Yes, I see Mr. Muhammad Imran has raised his hand. Sir?
May I?
Yes, please, sir.
Okay. Thank you, Professor Kokla. Muhammad Imran. I teach in Villa College, Maldives. I was a student of Stelina Jolie, ma'am, a year ago. Yes. So thank you for this interesting presentation, especially the comparative study between nuclear weapon case and then the climate issue. So do you think the way, ICJ, ICJ did not exactly clarify whether use of nuclear weapon will be prohibited or not, but can we argue that the countries which are involved in high number of carbon emission are also creating some kind of threat the way nuclear weapon creates? Having just the idea that a country has a nuclear weapon itself a big threat, right? You don't have to say anything. Can we like small island countries like Maldives, Sri Lanka and other, can they argue that these highly industrialized countries are also creating a threat to the small island countries just by being who they are?
Yes, Simran, thank you so much. And it's pleasure to meet someone in the neighborhood. And yesterday we had our MPhil and PhD inauguration at the faculty, University of Colombo. And then we in fact met a couple of students from Maldives. So it is very pleasure to meet you. And I really agree with you. Actually, that is exactly why I use this comparison between 1997 and 2023. This whole debate, the political debate between North and the South, it is eternal, and I don't think it will ever solve. So we have to deal with it. So how are we going to deal with that? Now, in 1997, this case majority was with the opinion that they brought out this self-determination, self-defense argument. Lawful and unlawful depending on the special circumstances of this particular self-defense debate. And Judge Veeramantri opposed that. He dissented, and then he said, under any circumstances, test of nuclear weapons should be not accepted. So the same argument actually in 2023, the World Youth for Climate Justice will have to face, because the world's most worst emitters are from industrial world. Some of the emerging economies like India and China also contribute in Brazil, South Africa, all the emerging economies. So how are we going to compromise this at the negotiation table? Because now polluter pays principle, common but differentiated principle, precautionary principle. Now look at these international environment law concepts and principles. They will define the parameters of state responsibility. And if you look at customary international law, Principle 21 of the Stockholm Declaration also provide states can take their own decisions according to their environmental policies and development policies, but they have state responsibilities not to cause harm to the neighboring states or beyond space. So this particular arguments can bring in. So I quite agree with you, Imran. Of course, the industrialist countries and the developed countries would not agree with this particular argument because they are the worst emitters. So you can see the number of developed countries who are in the Kyoto Protocol, who step out of the Kyoto Protocol and who are in the Paris Agreement and who are now almost getting out of the responsibility parameters. Now, many industrialist countries have not come up to the expectations. Of course, in EU, we can see some of the positive responses, but other than that, we can't see any sufficient contribution by the developed world. So again, in this particular case also, I'm anticipating that argument of getting out of the responsibility mechanism. So we have to anticipate that we have to better equipped with the philosophical arguments bring out by Judge Veeramantri in 1997. That is exactly why I want to show this youth that this judgment is. So please go through the dissenting opinion of Judge Veeramantri and see how you can defeat the argument, because anticipate that argument. The industrialist world will never give up bringing out that argument and stay out of the responsibility mechanisms. Yeah. Thank you, Imran.
Thank you.
Thank you so much, Professor. Thank you so much, Mr. Imran. If there are not any other questions, then Kokila ma'am requested me to release her at 4 and it's already 7 minutes late. So ma'am, thank you so much for joining us today. And we really hope that you will continue to guide us in the World's Youth for Climate Justice Asian Front and support us with all our future endeavors. And thank you so much, ma'am, for joining us. And thank you.
Thank you, Dulki. All the very best. And Ayubowan.
Thank you. Okay, so we have our next speaker of the session, Mr. Alan Ware, who also speak in the opening session as well, and he has kindly stayed to speak in this session as well. He's a peace educator and international peace and disarmament campaigner, originally from New Zealand. He has lived in the United States and Switzerland and now resides in the Czech Republic. Mr. Ware is the co-founder and the global coordinator of Parliamentarians for Nuclear Non-Proliferation and Disarmament USA Peace and Disarmament Programs Director for the World Future Council Germany and Director of the Basel Peace Office Switzerland and International Representative of Aotearoa Lawyers for Peace, the New Zealand affiliate of the International Association of Lawyers Against Nuclear Arms. He previously served as Executive Director of the Lawyers Committee on Nuclear Policy. Mr. Ware founded and directed the Mobile Peace Van and co-founded a number of other peace education initiatives, including Our Planet in Every Classroom, the Cool Schools Peer Mediation Program, the UN Decade for a Culture of Peace Schools Outreach Program, and the Global Campaign for Peace Education. He was a member of the Department of Education Advisory Group that developed the New Zealand guidelines for integrating peace studies into the national school curriculum. Mr. Ware was one of the leaders of the successful campaigns to prohibit nuclear weapons for New Zealand in the 1980s and to achieve a ruling from the International Court of Justice on the legality of the threat or use of nuclear weapons in 1996. He has co-founded a number of international peace projects and networks, including Abolition 2000, Middle Powers Initiative, Move the Nuclear Weapons Money, Unfold Zero, and No Fistules Global. He has won several peace awards, including the Right Livelihood Award, Alliance for Nuclear Accountability Award, World Peace Award, United Nations International Year for Peace Award, and Winston Churchill Memorial Trust Award, and has also been nominated a number of times for the Nobel Peace Prize. Sir, I welcome you to speak in the session too, and it's a pleasure and it's our honor to meet you and listen to you today.
Thank you very much. It was lovely to also see on screen photos of my dear friend, Judge Weeramantri, that Professor Kunasingi was introducing, who indeed was an incredible lawyer, a judge, humanitarian, visionary mind, and an inspiration to me. In fact, my first career wasn't in law, it was as a teacher. And I got inspired to get into law because of one of the cases that Professor Kunasinga mentioned, the nuclear test case in the Pacific. So I'm from Aotearoa, New Zealand. That's where I'm calling from today. And in our region, the nuclear weapons development involved the big powers, the United States, France, the United Kingdom, testing the weapons. By testing, it means they detonated them. And so they were exploding them in order to create bigger, more accurate nuclear weapons for the nuclear arms race. And that testing, even though it was conducted miles from populated areas, the contamination from the radiation from those nuclear tests has caused devastating health impacts, particularly on women and children in the Pacific, and continues to do so because the radiation lasts for generations, and the genetic damage it does in our bodies is passed through generations. So the nuclear weapons, it's not just if they are used in a war, it's the very production and the testing of them is already impacting on future generations and is violating the rights, the right to life, the right to health, the right to a clean environment of many people. And in the Pacific, we've felt that very strongly. And when I saw the impact of the nuclear test case in 1975, I was staggered. Until then, I hadn't even known there was an International Court of Justice. And then my country, New Zealand, along with Australia and Fiji, took France to the International Court of Justice over the nuclear testing in Moderator. By that time, the United States and the United Kingdom had already finished the nuclear testing in the Pacific, but France was still doing it. And the interesting thing was, even though France declared, well, we're not going to accept, what comes out of the court, we're a free country, they stopped the atmospheric testing the very next day. And to me, wow, I found this is really intriguing. Here we have a court that not everyone subscribes to. It's not compulsory jurisdiction for everyone in the world, like the courts in our countries are, and yet it can still have an effect on what the countries are doing. So I then started looking at, well, you know, law seems to have a lot more impact than I realized, including in the international realm. And I saw other cases, Nicaragua taking the United States to the court in 1982 over the United States support for the Contras. So the United States was supporting armed mercenaries, basically, who were fighting in the Nicaraguan government. And again, Nicaragua won the case against the United States, and that civil war ended very soon after. The military aid that the US was giving dried up. The US Congress adopted law saying you can't do that to the president. And then Oscar Arias, the president of Costa Rica, used that decision of the International Court of Justice, the Nicaragua versus US one, to build the framework, the legal and political framework for the Central American Peace Accords, which basically ended all the civil wars in Central America. Now, interesting thing is that you go through the history of the cases of the International Court of Justice, and you find time and time again that they actually help resolve these disputes, and they end up creating outcomes that end up protecting the people. And yet we hardly ever hear about it. You know, you don't hear about it on the news. And I then, that's why I got involved in this initiative to take the issue of nuclear weapons to the International Court of Justice. My country, New Zealand, decided nuclear weapons are bad. We're going to ban them. Our allied countries, the ones we were in close association with, did not like it. They thought that we were giving cover to the Soviet Union, you know, by being nuclear free. So they were putting boycotts on us, you know, economic sanctions on us, saying we couldn't do it because we had military alliances. So we decided, well, we'll take this case to the court. But what we felt was it was better to take the issue of nuclear weapons to the court, not our dispute with America or our dispute with France or our dispute with the United Kingdom over their nuclear weapons issues. So this is where we did this advisory opinion, which Professor Kornesing had talked about. And that's when I left New Zealand and moved over to New York to set up the process for getting the UN General Assembly to adopt the resolution, which is like where we are at the moment now for the climate case, and then take it to the court. And one of the things, some of the lessons I think on this process from this one is, one, you may be politically weaker than these powerful political elements, like we, you know, small country New Zealand and other small non-nuclear countries challenging the power of all the nuclear armed states in the world. You know, the permanent members of the Security Council, the ones who have incredible lobbying power, and they were lobbying hard to make sure we didn't get this decision from the UN General Assembly, but we beat them because we had the moral majority. And I say that in a positive way, you know, the moral, ethical majority, that the nuclear weapons, these are immoral, they're unethical, they're inhumane, and illegal. And that's what the legality part we needed to have affirmed by the International Court of Justice, because the nuclear weapon states were saying, there's no law banning nuclear weapons, show us the treaty that we've signed on to, you know, saying we're not allowed to use them. There isn't one. So that's why we need to go to the court. And here's where I come to a couple of things that Professor Kornesing mentioned. And that is that the court, and this is a really important thing, the International Court of Justice is not just dealing with treaties. And a lot of people think that international law is just based on the treaties that are agreed between countries, but it's not. International law is much broader than that. And that's where Judge Weeramuntry has contributed so much, because he has demonstrated through his legal writings, through his books, and then later on through his position on the International Court of Justice, the truth of what is the body of law that is applicable to key issues, whether it's nuclear weapons, whether it's climate change, whether it's water resources and the environment. The body of law is broad, and this is accepted in the Charter of the UN and the Statute of the International Court of Justice. They say 4 sources of law. The first one is treaties and agreements. Then the second one is customary principles of law that are accepted. Next one is like judicial decisions, and then the next one is the writings of legal and experts. So you have like these 4 sources that actually build in to the decision. So when we came into the court, it's true, there was no treaty that was prohibiting the threat or use of nuclear weapons. But the customary law included international humanitarian law, laws of peace and security, the UN Charter, and then the general principles of law applicable. And you apply those to nuclear weapons and you come up with a decision which the court said, the threat or use of nuclear weapons is generally illegal. That was the conclusion. So what does that mean? The threat or use of nuclear weapons is generally illegal. Professor Konasinga mentioned the part, but we can't really work out whether they're legal or not in the extreme circumstance of self-defense when the very survival of a state is at stake. But even in that circumstance, international law still applies. Basically, what it means is that the court affirmed that the threat or use of nuclear weapons is illegal in 99% of cases. And that 1% that's remaining, they said, we can't work out whether that's legal or not. And Judge Wieramuch was saying, even in that 1%, it's illegal. So that was his dissent. It wasn't against the main thrust of the decision of the court. He just basically said, look, there's no uncertainty even in that 1%. And he was right on that. That since then, we've had the decision from the UN Human Rights Committee in 2018 applying human rights law to nuclear weapons. There was no caveat. The Human Rights Committee said that the threat or use of nuclear weapons would violate the right to life, full stop. And this was really important, but the first one was also because in 96, it was 96, July 8th, when the ICJ gave its advisory opinion, that phrase, the threat or use of nuclear weapons is generally illegal, is basically turning the Lotus principle on its head with regards to nuclear weapons. The Lotus principle is that if something is not specifically prohibited in international law, then it's permitted. And the court said that no longer applies to nuclear weapons. So before the decision in 96, the nuclear weapon states could basically plan whatever type of use, threat of use of nuclear weapons they wanted to, and no one could really challenge them. Now, the law says no. We assume that the use or the threat of use is illegal unless you can prove otherwise. You would have to prove that a threat or use would be legal. This is starting to develop and it's been quite strong, what we say is a normative taboo against the threat or use of nuclear weapons. And that's strong. We've seen that even from the G20 leaders, for example, which included the P5 plus India, so 6 of the nuclear armed states in November last year. They actually agreed in Bali, the G20 summit, that the threat or use of nuclear weapons is inadmissible. They didn't quite get to the totally illegal and 100% times, but that's really close to that. So this is really important. It shows that the legal path is really, really important. It has an impact, and that the law is much broader than just the treaties. So all this paves in well for the climate case. Because we're facing some similar obstacles. There's very powerful political forces, that want to keep the fossil fuel industry going. They create lies, about our economy could not survive, if we don't, continue with our fossil fuels, and to fast track to a green economy would destroy jobs, would destroy our economy. These are all lies, but they have so much money and so much power. They're very persuasive and got political power. But here, this is where a decision from the International Court of Justice will basically clamp them down. And it's like, it'll be superior to their arguments. They will no longer be able to say, well, in our country, we can't go fast to a green economy because our next door neighbor isn't doing it. We'll be at a disadvantage. They won't be able to say that, because the decision from the court will apply to everyone. So that's why it's important. It's more important. I mean, the national cases are important. The Uganda case in the Netherlands is important. The case in the Philippines, which established what we would also want in the International Court of Justice, but it can't just be done at a national level, because then you've still got nations competing against each other, and some will feel constrained and others won't, and we're not going to get the combined action that we need from the entire global community. That's what the International Court of Justice can provide. That's what we can build. And to do that, we still have to beat them, not just in the General Assembly, which is the current campaign, get your country to join as a co-sponsor. But then once it gets into court, we can't just leave it to the judges. It's going to be very important for us as civil society to work with like-minded governments to present both the scientific facts, the examples that climate change is already here, the damage that it's doing, the economic cost of climate change to balance against, what it'll cost to change to a green economy, which is less than what the economic cost of climate change will cause if we allow this to keep going. So all these facts and the scientific evidence has to be there, but so too do the stories, so too do the personal stories of people and communities that have been impacted by climate change. And I'll give an example with the nuclear weapons case. There was legal arguments from both sides, from the non-nuclear states presented about why nuclear weapons are bad and illegal. From the nuclear weapon states, they were saying how nuclear weapons keep the peace, and so why they're imported. Then we had the stories come in, and the judges, you could see, were like weighing up one with the other. Then we had some personal stories coming in, and I think the most powerful one was Lijong Eknilung from the Marshall Islands. And the Marshall Islands is one of these places which has been impacted by the nuclear tests. 67 nuclear tests from the United States. It took Lijong 3 days to travel to get to the court, because the Marshall Islands, there's no direct flight from the Marshall Islands to The Hague. She had island hop, to Hawaii, and then to then to the United States, and then it took 3 days for her to get there, but it was worth it. When she spoke in the court, she spoke about her personal experience as a woman in the Marshall Islands who had 8 miscarriages. She wasn't able to give birth to a live baby. Some of those miscarriages were deformed. One had one eye, another one looked like an octopus. She was telling these stories, not just her. So many women in the Marshall Islands had the same experience of giving birth to things they could not even describe, how they're so deformed. And this was in a country, where the nuclear tests, when they were conducted, were done a couple of 100 miles away, when the wind was blowing in the other direction, during peacetime, when the governments could decide we want to do it safely, which you can't do during wartime. And so what they demonstrated is that any use of nuclear weapons, no matter if it's dropped on a military target a long way away from civilian population, will impact indiscriminately on humanity and on the environment. There is no way to stop nuclear weapons from being indiscriminate, which was the arguments the nuclear states were using. This came up, so the court then confirmed, said the destructive impact of nuclear weapons cannot be contained in time or space. Once they came to the conclusion, the final result on the law was going to be evident. They were going to find against nuclear weapons. I think they're going to find the same with regards to climate change, time and space, the impact on future generations. Climate, it knows no borders. I think they'll come up with the same understanding, which will then lead to really strong legal obligations. And the obligations are both negative, what you can't do, you can't keep pumping carbon into the atmosphere. The positive obligations, what you have to do, you have to shift fast to a green economy, and you have to look at people and communities who are already being impacted from climate change and work out how to restore those communities. There are already communities destroyed. There's already climate refugees. So the court come down with both, but we will need to participate to make sure that happens, by being there, by working with like-minded governments, by bringing the stories to the court, and also bringing the issue, the case in the court, to the public, so they know that it's happening. The media won't just turn up there unless we tell them to turn up. The media won't go think it's significant unless we tell them it's significant and tell them why. So that's where the work of the World Youth for Climate Justice is so important. The Pacific Island students fighting climate change, where this grew up from, educating young people about, look, there's this International Court of Justice. It means something. It has an impact. It's going to, if it comes down with a good decision, which we believe it will, it's really going to make the huge difference that we need, on the stalled area of climate action. So get them behind it and make this a big buzz. And if we make it a big buzz, then the media will then make it a big buzz, and that will ensure that the follow-up then happens, which is really important after the court comes down with its decision. So I'm, as I said, really inspired by all this. I have so much respect for the young people who are leading this campaign. Also, thanks to the governments who have listened to the young people, and it started with the Pacific Island governments first, Vanuatu, and then some of the other Pacific Islands, and now 115. So keep this up, have hope, have faith that you can get this case to the court, that you can win it, it'll make an impact, but don't just sit back and let others do it, get involved, and everyone can make a difference. Thank you very much.
Thank you very much, sir, for sharing your experiences and your expertise, and also for the kind reminder that our fight just starts. We have a lot to happen after this March. And it was really such a pleasure to hear you speak, and thank you so much. And we have a request that we should leave the question and answer session to the very end of the of this session. So I will move on to our next speaker. We have Justice Dr. Masroor Salekin from Bangladesh. Sir has more than 17 years of experience as a judge, a researcher, a teacher, and a legal practitioner. He completed his PhD in law from the University of Galloway, Ireland, funded by the prestigious Hardiman Research Scholarship. And his research topics include environmental justice, judicial activism, separation of powers, and collaborative constitutionalism. He completed his Master of Laws in International Law and Development from the University of Nottingham as a Chevening Scholar. He's currently working as an additional district and session judge in Bangladesh judiciary. His scholarship has been published or is forthcoming in Environmental Liability, Law, Policy and Practice Journal, Law, Environment and Development Journal, IUCN Academy of Environmental Law Series, Judicial Administration and Training Institute Journal, South Asian Journal of Environmental Law and Policy, and the Bangladesh Law Commission Digest. Currently, he is an adjunct faculty at the Bangladesh Aviation and Aerospace University, Dhaka International University, and Bangladesh University of Business and Technology. Sir, we would like to welcome you and thank you so much for accepting our invitation to speak on the session. And over to you, sir.
Thank you, Dulki. Am I audible?
Yes, sir, you're audible.
Yeah, so good afternoon. I must appreciate Walls Youth for Climate Justice and all the partner organizations for arranging this event and working so hard to gather worldwide support for a UNGA resolution requesting an advisory opinion from the ICJ. And definitely thank you, Dulki, for inviting me to this very important event, which has given me an opportunity to join the global fight against climate change. And I must agree with what Professor Kokila said and Eleanor said. The advisory opinion definitely has a huge role to play. And this is just the beginning. We must not sit idle and wait for something happens. Definitely, we have to work hard to make this happen in the coming days. And being a citizen of a developing country, Bangladesh, I know how crucial the fight against climate change is and the significance of this noble initiative. So today I will discuss how a developing country like Bangladesh is suffering for the changing climate, and how the government and the courts have reacted in that regard. And focusing on the climate case Ireland, my discussion will also show how important an advisory opinion by the ICJ can be, not only for Bangladesh, but any country in the world. So as I said, my presentation would be mostly related to climate injustice, the procedural inequalities, and need for an advisory opinion from my country perspective. And obviously, this would be very much related to any of the countries in the world, particularly the small island states and the developing countries who are suffering most because of climate change. This picture explains everything, I guess. This is the poor people who are the most vulnerable to climate change crisis. This one picture from the left-hand side is from Bangladesh, and the right and side picture is from India. Both shows the misery of the people who are suffering from flood. They have to leave the houses behind. Many of them lost their houses, and they have to live in the government cyclone shelter projects for like months and days without any food for many days, or maybe one meal in a day. So this is really terrific. Like, I mean, they are suffering the most, and they have no one to say their voices and to hear the voices. So we must understand the nexus between climate change and human rights, and to understand the full impact of climate change. So we have to understand how countries like Bangladesh are facing the trouble and the vulnerability of climate change. Bangladesh is considered one of the most climate vulnerable countries in the world. And according to Global Climate Risk Index of 2021, Bangladesh is ranked 7th among the countries affected most in 2000 to 2019 due to climate changes. Though its contribution to global warming is negligible, less than 0.48% of global emissions, the country is impacted by all the adversities of climate change. And I think the same happening with India, Sri Lanka, Pakistan, Maldives. We're all suffering the same way, though we have very little contribution to global warming. And Bangladesh is susceptible to floods, tropical cyclones, storm surges, and droughts. Climate change will exacerbate many of the current problems and natural hazards to the country faces. As we all know, sea level rise is the biggest threat for Bangladesh among all the external drivers. And about 12.34% to 17.95% of the coastal areas will be submerged due to SLR by this century, which is really unfortunate and really frightening. We also are facing heavier and more erratic rainfall during the monsoons, resulting in higher river flows, river bank erosion, increased sedimentation in river beds, as we have seen in the pictures at the very beginning, and how people have to leave the houses because of floods. Along with this, melting of the Himalayan glaciers, leading to higher river flows in the warmer months of the year, are also adding more crisis to the whole problem. So all these changes threaten the food security, livelihood, and health of the poor, people living on river islands and along the coastlines, among the poorest people in the country. They will be seriously affected, as will others who lose their land to river erosion. Extremely poor households throughout the country, including many female-headed households, will suffer the most from climate change. As the pictures again shows, like in cyclones, people are losing the houses, the homes, how drought is affecting the country, and how people are suffering from lack of food, resources, and capacities. And climate change hazards is not only affecting the people living in the rural areas. This is also affecting the people who are living in the urban areas, because higher rainfall will definitely cause more serious problems, and sewers frequently back up in the monsoon region in the urban areas of Bangladesh. As with many other countries in the world, the Bangladesh government has also adopted a number of policies saying that, this will definitely help to win the fight against climate change. We have the Bangladesh Climate Change Strategy and Action Plan of 2009, which has been updated in 2022. We also have many other national level policies like the Bangladesh Climate Change Trust Act. We have National Adaptation Plan. We have Bangladesh Climate Fiscal Framework, Disaster Management Act. The list is very long. I'm not going to read out every detail of this whole list, but we have a number of policies. And what is most important is that we have National Solar Energy Roadmap. We have the Bangladesh Energy Efficiency and Conservation Master Plan. We have Renewable Energy Policy of Bangladesh. So it seems that the government has adopted a number of policies, but are they really impacting our lives in the practical level? If we go to just one example, like the Renewable Energy and Energy Efficiency Initiative in Bangladesh, we have seen that the government has a number of policies in this regard. But unfortunately, renewable energy production accounted for only 1% of the country's total power generation, which is very much negligible. So whatever the government has been trying, that has not been tested, that has not been properly implemented. And there is lack of accountability and transparency in the government initiatives. According to the Deputy Chief Information Officer of the Ministry of Energy of Bangladesh government, the main problem in planning for solar power is the scarcity of land. Many initiatives linger due to land shortages, and they are looking for a way out to solve the land crisis. This would be highly challenging in a densely populated country like Bangladesh, because no matter, the lands are not going to increase in our country. Definitely the population is increasing on the other hand. So I'm not seeing any point how the government is thinking to deal with these issues of renewable energy, of the scarcity of land issues. And since independence, the government of Bangladesh, with the support of development partners, have invested in several projects like the flood management scheme. We have the flood protection and drainage scheme. We have coastal embankment project, over 2,000 cyclone shelters to provide refuge for communities from storm surges caused by tropical cyclones, and 200 shelters from river floods. We have comprehensive disaster management projects, including community-based programs and early warning system for floods and cyclones. But unfortunately, the government initiatives were not sufficient to ensure climate justice in the country. There is a lack of accountability and transparency while dealing with funds and implanting various climate change policies. Definitely, we all want justice, and we all are with World's Youth for Climate Justice and this call for UNJ resolution to have a WYCJ advisory opinion. And not only these problems in implementing various policies of the government, we are also suffering from various procedural inequalities. Research shows that in Bangladesh, access to information, public participation in climate decision making, and access to justice has been suffering due to cumbersome proceeding, bureaucratic inertia, cost, and long delay. We have several laws which are requiring access to environmental information requested in national laws, but there are instances of defying laws by public authorities who also chase general people for the alleged violation of the law just to justify their own development projects. We have relevant laws and policies which hasn't increased the participation of the poor people who are having lack of access or public participation in different government-run development projects. We have heard the name of the Rampal power plant project, which has been initiated by the government in the Sundarbans, which is threatening for the Sundarbans as well. But the local people had a very little chance to express their opinion regarding that particular project. So how our courts have been reacting to this whole thing? As you all know, that the courts are the only institution in the state machinery that allows people to hold government, agencies, corporations, and individuals accountable for any violation of the fundamental rights. However, the path to the court is never easy and is strained with hurdles, making it difficult for individuals to access the forum to defend their rights. Considering the difficulties, judges have emerged as a protector of the environment. Following the instances from other South Asian countries like India, Pakistan, and Sri Lanka, judges in Bangladesh have also attempted to expand access to environmental justice by relaxing several procedural norms. Our courts have recognized the constitutional right to the environment back in 1997. And this growing trend of judicial environmental activism in Bangladesh has stimulated legal and environmental activists to challenge various government actions and inactions under the umbrella of the flourishing right to the environment. And judges have turned to be a savior of the environment. We have seen several cases where the court have issued directives to the government, either regarding air pollution or regarding industrial pollution. As you all know, even though the courts have been trying, the air quality of Bangladesh, particularly the capital Dhaka, has not been very good. In the last couple of months, we have been fighting really hard to have the #1 position in air pollution in the world ranking, which is a shame, I would say. But although the courts have been very active in various environmental issues, the courts have been silent on any climate change issues or any issues which related to development-induced initiative of the government. For example, the Rampal project, which is a coal-based power plant near the Sundarbans, which is the largest mangrove forest in the world. The project's impact area falls more than 10-kilometer radical distance, which is within the environmentally critical area of the Sundarbans. When this issue was taken to the Honorable Supreme Court of Bangladesh, the High Court Division refused to intervene. A public interest litigation was filed seeking direction to the government to stop the construction of the coal-fired power plant until an assessment of the project's environmental impact was done. Even UNESCO issued notifications to stop this particular project. But the court, while summarily rejecting the petition, termed the attempt by the petitioning lawyer to be overactivism and actuated by publicity motive, which is again a big shame. So we also are facing problems in the public interest environmental litigation in Bangladesh. In our country, PIL is suffering from the lack of accessibility for the poor due to its elitist character, undermining the focus on social justice and socio-economic empowerment of the poor and disadvantaged. The rights group organizations who have been behind the most PILs are driven by limited resources. That's why Still today, we don't have any climate litigation in our country. Though we have examples from Pakistan, they had the first climate litigation back in 2012, even before the famous Argenta case or even before the famous climate case of Ireland. So definitely, we require urgent climate action, and this is very crucial for Bangladesh. According to World Bank's Group's Country and Climate Development Report for Bangladesh, without urgent action, including further adaptation and resilience measures, the country's strong growth potential could be at risk. Climate change will hit poor and vulnerable people the hardest, as we all know this. Average tropical cyclones cost Bangladesh about $1 billion annually. By 2050, a third of agricultural GDP would be lost and 13 million people could become internal climate migrants. In case of a severe flooding, GDP could fall as much as 9%. And as I said, climate litigation, we have no examples in Bangladesh of filing any applications by any of the organizations or any individual, and therefore the court hasn't come up with any decision. But as we have seen in other countries, that climate litigation can be a very effective thing to make the government to adopt new policies. For example, the climate case Ireland, where the Supreme Court of Ireland quashed the government's national mitigation plan because the plan failed to specify the manner in which it was proposed to achieve the national transition objective as required under the 2015 Climate Act. Subsequently, the government is working towards adopting a new policy for Ireland. As I already mentioned, in Pakistan, through the Asghar Leghari case, where the court decided that the national government's delay in implementing the country's climate policy framework violated citizens' fundamental rights, provided a new dimension to worldwide climate litigation. In Bangladesh, though the courts are very active in environmental issues, we haven't seen any climate litigation. Here, what advisory opinion can do? It can obviously serve as a basis for domestic climate litigation to the extent a country's domestic courts differ to advisory opinion about international law. It can also alert the people regarding their right. As the youths have already risen, I hope that all people from 5 years old till 90 years old, everyone should come forward. And if they are aware, I believe that the International Court of Justice has to make a decision and the countries has to come forward. We have seen enough, I think, and it's time for us all to work forward, because this advisory opinion definitely will be a platform, will be a big foundation for many people who are working to save the planet, to save the environment. As Professor Kokila said in the beginning, we have to work for our kids, for other kids, for the future generation, and for our generation, because we have to survive our lives, and our future generations have to survive as well on the same environment that we are leaving behind us. So this advisory opinion could also serve as a basis for strong institution to climate justice in many countries. As we know, in Bangladesh, we had one Environment Courts Act of 2000. Unfortunately, the government has only established 3 courts out of 64 districts. So I would say such kind of initiative by the ICJ might also influence the government to have more strong institutions to ensure climate justice, which will be make justice available for the poor people who has a lack of access to justice because of there is a lack of institutions for ensuring justice. So here I conclude, and thank you again, Dulki, and thank you the whole team for organizing this wonderful event. Thank you very much.
Thank you so much, sir. Thank you so much for shedding the light on the immense issues that are faced by developing nations, including Bangladesh, Sri Lanka, and India because of climate justice, and the impact an advisory opinion from the International Court of Justice can make, not only in the international arena, but also in the national legal frameworks as well. Thank you so much, sir, and thank you so much for accepting our invitation once again. Now I will move forward to the final speaker of our session, Mr. Mohammed Imran. He's from Maldives. He's a lecturer of public international law at the Faculty of Sharia and Law, Villa College in Maldives. He also teaches LLB and LLM programs offered by the University of West of England, Bristol at Villa College. He completed his master's from the South Asian University, New Delhi, sponsored by the SAARC countries, and the BALLB from Aligarh Muslim University, Aligarh. He has got several articles published in reputed law journals such as Asian Journal of International Law, Indian Bar Review, IUP Law Review, and etc. He has been the co-editor of 2 books, Access to Justice, Need for Reforms, published by the Faculty of Law, AMU Murshidabad Center, and the Technology-Based Violence Against Women, published by Rigi Publication as a project with Kalki Soj. We are honored to have you today with us, sir, because you will be discussing the impacts of climate change on an extremely vulnerable state such as the Maldives. And thank you so much for accepting our invitation, and over to you, sir.
Thank you, Dulki. I hope I'm audible perfectly.
Yes, sir.
Thank you
Yes.
for kind invitation and introduction. So I don't have PPT, I'm sorry for the audience, but I will try to be as precise as possible and mention some of the important issues which are, I mean, somewhere relevant more for the SID small island countries than for other countries. So I'll start with the observation that I know this advisory opinion is going to help all the countries irrespective of their, whether they are vulnerable to climate change or not. But with this advisory opinion and the discussion that we are having, we should focus mostly on vulnerable, if not the most vulnerable countries, because generalization of the problem of climate change will also, ignore the problems of the vulnerable countries. For example, India also has a problem of climate change, but India did not support this resolution. And I'm not sure if they are going to become supporting the advisory opinion somehow. Pakistan also did not support, Bhutan did not in South Asia alone. And Pakistan and India, both including Bangladesh, I mean, all the South Asian countries are vulnerable to climate change. The thing I wanted to mention, for example, let's say if there is a sea level rise in coming 5 or 10 years, maybe few centimeters, Maldives may submerge under the sea, but it will not impact India to that extent. And therefore it is important to address this. I mean, from my perspective, this advisory opinion from small island countries perspective, not from Bangladesh or India. I'm sorry, I'm trying to be blunt, but it's important. So for Maldives, it is so important that Maldives has started this practice of called land reclamation, right? So they've started making new artificial lands because they don't have land. Just to give one data from Maldives government, among all the areas that Maldives has in its jurisdiction, 99% is covered with the seawater, and only 0.331% is dry land. Other lands are wetland; they are not dry land. I mean, you have to create artificial islands and others. So there are more island countries like Maldives in the world. And also, like Maldives is it's a piece of land which is fragmented into small islands, unlike Sri Lanka. So Sri Lanka is like one big island, but Maldives, you split the Sri Lanka into different pieces, that would become Maldives, which makes more vulnerable. Now, to talk about Maldives, I have divided presentation in 3 important segments: the complexities that Maldives has, and then what are the initiatives that Maldives has taken so far, and how this advisory opinion can help. So, as I just mentioned, that Maldives is one of the most vulnerable countries when it comes to sea level rise. In Maldives, the issue of development, sustainable development is also high, because Maldives gets a lot of aid from UNDP, Max Planck, European Union, US, and so on. And also it is one of the countries which gets highest, I mean, even during COVID, it was a country that received highest investment, foreign investment for infrastructure and tourism business. So in Maldives, the issue is not about the development versus environment. It's about existence versus sustainable development, right? And therefore, any act of infrastructural development is very tricky. For example, in India, one can argue that you have to protect the forest because you have enough land. But let's say Maldives tries not to create an artificial island and saving its lagoon and reef area, it will save the existing ecology for a few years, but that island may not, remain there in few years, like maybe in 10 or 20 years, right? So when a piece of land is not livable, someone has to do something. And when Maldives tries to create an artificial island, it is going to lose the beauty, going to affect the ecology, environment, and lagoon. So it's more tricky than for other countries. And talking about its internal laws that Maldives has, starting from the constitution, Article 22 of the Maldivian constitution also says that it is a fundamental duty of the government of Maldives to protect the ecology, biodiversity, and the natural environment of the Maldives, including the beauty, because that is how the tourism business works. So protection of beauty of Maldives in terms of reef and lagoons and everything is also important for the government of Maldives. Quickly on the contribution that Maldives has made in terms of its state practice, we don't have cases from the Supreme Court, and that is, I think, because of the democratic erosion due to their own internal politics. But aside that, different governments since 2008 and also before have taken some good initiative with reference to climate justice. One very significant is Mali Declaration on Global Warming and Sea Level Rise of 1989. This, I mean, in Southeast Asia, this is one of those important declaration that was submitted to UN General Assembly. And in this declaration, Maldives did not only talk about, having a long-term and short-term plan for climate justice issues and exchange of information between SID's countries, but it's also, asked the small island countries to use or seek assistance from UN and other agencies of United Nations to clarify the rights related to climate justice. I think I would like to interpret this in a way that this is the current advisory opinion is just extension of same kind of idea that small island countries were having, seeking assistance from ICJ or having an advisory opinion is one of those aspirations that this declaration had. In 2021, and I'm just skipping a lot of information, but we can have that in question and session. In 2021, when the Maldives was, chairing the Human Rights Council, the foreign minister of Maldives, Mr. Abdullah Shahid, he tried to invite countries and tried to seek their attention on the issues of climate change, even when the COVID was, dominating all the areas of research and, investment. So I think for Maldives, climate change has always been important and you can say a top priority when making a policy. But apart from these things, there is one thing that we have to address, and this is, I mean, among all the climate change issues, the first priority that I want to mention that Maldives has right now is maritime delimitation. So everyone must be knowing about the case between Mauritius and Maldives regarding the maritime delimitation. So what's happening is that due to sea level rise, island countries like Mauritius and Maldives and maybe Sri Lanka also, they are going to lose some pieces of land, right, compared to big countries. And in its submission to United Nations International Law Commission, Maldives has said that any loss of land should not change maritime boundaries between the countries established by the treaty. For example, India, Maldives, and Sri Lanka has, tripartite agreement regarding equidistance maritime limitations. This idea of Maldives that it will not change maritime boundaries is important because under international law, there is no guarantee to the state that is going to be submerged. For example, Tuvalu, I'm not sure if Tuvalu can claim any kind of sovereignty over the land, which has been lost. And also there is no positive obligation on any state as of now. That's why we have this advisory opinion. And if you see the Montevideo Convention, it says that to be a state, you need to have a territory. So imagine about the countries who don't have a territory, and even Convention on the Law of Sea says any island will not become just a piece of land for the purpose of state. It has to be livable. I mean, there has to be habitations. If people can't live on the piece of island, piece of land, it cannot be considered as a territory in the sea, right? So it's like Maldives submerging under the sea, and you can't live here, but still there is a land, right? That land may not be considered as good enough to claim the status of state under international law if you go for the definition of Montevideo Convention and on clause 3. And that's a very serious concern for countries, small countries like Maldives. So all these things, if we take together, we can understand that how important this advisory opinion is going to be for any countries which is going to be, which is affected. Among other things, we also know that small island countries are the least emitters of the carbon emission, right? And they are the first victim of the carbon emission in terms of sea level rise. Okay, so there are debates, certain debates that say that those countries who are going to, polluter pays principle, I think Professor Kokila also mentioned, but there is no customary international law which actually says that the countries who are going to emit, or emitting carbon are responsible for the loss of land or sea level rise directly, right? Or at least we don't have any, let's say, a fund, climate change. I think Bangladesh created one climate fund few years back. I'm not sure if it is still there, but they have it like internally. So we may also think of having some kind of climate change fund to support the countries who are fighting climate change, because I know both Sri Lanka and Maldives has high debt to pay from IMF and from any other countries. And if we see their income, so let's say if their total income of both these countries are 100, out of 100, 60 to 70% goes to climate change issues, right? Creating artificial island maybe, and investing in the areas to mitigate the effect of the climate change. And then these countries have to pay the debt also from IMF, or let's say for taken from any other country. And then there remains little to contribute for the development of the country. And so it is going to affect the education, the sustainable development, food security issues. So everything is, if we club together, has a lot of effect on how the world sees these countries' position, right? And these countries are not vulnerable just because where they are. These countries are also vulnerable on how others are treating their territories. So we have this transboundary harm principle. Although the direct effect of transboundary harm, has this idea that the countries can claim reparation, but the sea level rise is not the direct effect. It's a indirect effect. So a country in like India and China are emitting carbon. A country in, let's say, in some places in America, they're highly industrialized countries. How much carbon emission they do has a deep impact, right? But we can't directly, there are scientific proofs, but it is not as direct as someone, let's say, having a factory in his country and the pollution directly goes to the other country in the neighboring country, because that is more visible, conceivable. But the impact has been proven by the scientists, I think, regarding the sea level rise and the carbon emission. So with these things, I think I'll end, and I would like to have, if there are any questions, we can be a bit more engaging. Thank you, Dulki.
Thank you so much, Imran sir. It was really fascinating to hear you speak, and to be honest, I didn't know that India is not supporting for the advisory opinion. So I we have make note of it, and now our members from the WYCJ will be working on this.
Yeah.
So thank you so much, sir. And now I'd like to open the floor for questions. If you have any questions, then you can raise your hands or type your and share your questions in the Q&A box. Are there any questions?
I think someone's typing. Just Mr. is typing at something. It looks like maybe sir can speak, then that would be better.
Sir, you can, Dr. Salekin, sir, you can speak if you like.
I was not typing, like someone else was typing,
Oh.
maybe.
Okay, okay.
It shows. I thought maybe you're.
No.
Okay.
I've been
Okay.
waiting for questions if there's any.
Yeah.
Does that mean we do not have any questions?
Maybe we all are very clear that, I mean, advisory opinion is
Yes.
the most important thing. It should come.
Yes.
Like, there is no confusion
Yes.
regarding this particular issue. So
Yes.
Yes. It's already 5 p.m. So I guess we can conclude this session. And I thank all of you, to Professor Kokila Konasinghe, Mr. Alan Ware, Justice Dr. Masroor Salekin, and Mr. Muhammad Imran for taking your precious time and sharing your expertise and insights on the advisory opinion on climate justice from the International Court of Justice. And thank you so much for joining the session 2 of this conference series. And I would like to invite all our participants, if possible, to join us for our next sessions as well. We have our next session 3 on Europe, starting at 5:30. So until then, thank you so much, and take care, and thank you for joining. Thank you. Bye-bye.